In 2008, a Texas surgeon was hit with a malpractice judgment worth $4.2 million. The plaintiff's attorneys went hunting for assets. They found his investment accounts. They found his rental properties. They found his boat. They found nothing else. His primary residence, worth $1.8 million, was untouchable. His retirement accounts, over $2 million, were untouchable. The bulk of his liquid wealth sat inside a trust structure that, legally, he no longer owned in the way the court needed him to own it. In the end, the judgment collected against a fraction of what he was worth. That same year, a different physician, similar income, similar exposure, no such structure, lost almost everything in a comparable suit. Same profession, same risk, two completely different outcomes. The difference wasn't luck. It wasn't a better lawyer during the trial. It was a decision made years earlier, long before either of them was ever sued. This is asset protection, and most people don't find out how it works until it's already too late to use it. Welcome back to the Wealth Archive. Beat 1. The problem frame. Most people think of wealth as a number, a total, the sum sitting across their bank accounts, their brokerage, their home equity. But that number is an illusion of security, because wealth, unprotected, is not actually yours in any legal sense until the moment someone tries to take it and loses. A lawsuit, a business failure, a divorce, a single bad driver on a single bad night. Any one of these can turn a lifetime of accumulation into a single line item on someone else's judgment. Here is the trap almost nobody sees coming. The wealthier you become, the bigger the target on your back grows, and the less most people do about it. They spend decades building the asset side of the ledger, and almost no time building the wall around it. That wall has a name: asset protection planning. And contrary to what most people assume, it is not something reserved for billionaires with island trusts and private jets. It is a body of entirely legal structures used by physicians, business owners, landlords, and investors, designed to separate what you own from what a creditor can actually reach. The wealthy don't get sued less often. They just lose less when they are. Beat 2. The case study. Go back to the surgeon. Years before the lawsuit that could have destroyed him, his advisor made one recommendation: stop owning assets directly. Not selling them, not hiding them, restructuring who, legally, held title to them. His rental properties were moved into separate LLCs, one per property, so that a lawsuit tied to one building could never touch the others. His investment portfolio was placed inside an irrevocable trust, meaning he no longer had direct legal control over it, which is precisely what made it unreachable. His home sat in a state with an unlimited homestead exemption, meaning state law itself shielded it from most creditors regardless of value. His retirement accounts were already protected under federal law, untouchable in nearly any civil judgment. By the time the lawsuit landed, there was almost nothing left in his own name to seize. This is the architecture. Not one wall, several, layered, each covering a different category of risk. Beat 3. The 4 pillars of the wall. Ask any asset protection attorney, and the strategy breaks down into 4 repeatable pillars. Pillar 1. Entity separation. The single biggest mistake ordinary investors make is owning everything personally. The rental property, the side business, the equipment, all under their own name. One lawsuit against one asset then exposes every other asset in their life. The fix is boring but brutally effective. Put each risk-bearing asset inside its own LLC. A tenant slips and falls at property A, they can sue property A's LLC, and nothing else you own. Pillar 2. Trust structuring. Ownership and control are not the same thing, and creditors can only reach what you legally control. An irrevocable trust removes an asset from your direct ownership while still allowing it to benefit you or your family under the trust's terms. Certain states, Nevada, South Dakota, Delaware, have built entire legal industries around domestic asset protection trusts, specifically because their statutes make these structures extremely difficult for outside creditors to pierce. Pillar 3. Insurance as the first line. Structures matter, but insurance is what absorbs most claims before they ever reach the legal architecture underneath. An umbrella liability policy, often costing a few $100s a year for $1 million or more of coverage, is the cheapest asset protection tool that exists, and the majority of wealthy households still underbuy it. Pillar 4. Statutory exemptions. Certain assets are protected by law, regardless of any planning at all. Qualified retirement accounts. In many states, life insurance cash value and annuities. In a handful of states, an uncapped homestead exemption on a primary residence. Knowing which exemptions your state offers and structuring your balance sheet to take advantage of them costs nothing beyond the knowledge itself. None of these pillars work in isolation. A trust without insurance leaves you exposed to smaller claims. Insurance without entity separation leaves your entire net worth attached to a single lawsuit if the policy limit is exceeded. The wealthy stack all four, so that no single point of failure can bring the whole structure down. Beat 4. The timing problem. Here is the part almost nobody tells you, and it is the single most important detail in this entire video. Asset protection only works if it is done before the liability exists. Every one of these structures, the LLCs, the irrevocable trusts, the strategic titling, can be unwound by a court if a judge determines they were created specifically to dodge a claim that already existed or was reasonably foreseeable. The legal term is a fraudulent transfer. Move your assets into a trust the week after you get served with a lawsuit, and that trust will not save you. It will be reversed, and you will look far guiltier for having tried. This is why the ultra-wealthy build these structures early, quietly, as a matter of routine, long before there is ever a reason to. It is not reactive, it is preventative, the same way you buy fire insurance before the fire, not after the smoke alarm goes off. The people who lose everything in a lawsuit are rarely the ones who did nothing wrong. They are the ones who waited until the moment they needed protection to start looking for it. Beat 5. The escalation scale, this beyond one surgeon, and you start to see why this matters at a societal level, not just a personal one. Every year, hundreds of thousands of civil lawsuits are filed in the United States alone. Business owners, landlords, doctors, contractors, anyone whose work carries liability exposure lives one incident away from a judgment that can erase a lifetime of work. And yet study after study on financial literacy shows that the overwhelming majority of small business owners and real estate investors carry no liability structure beyond basic insurance. Meanwhile, family offices managing 9- and 10-figure fortunes treat asset protection as a non-negotiable first step, not an afterthought bolted on after the wealth is built. Multi-generational families don't wait for a lawsuit to structure their holdings. They structure first and build wealth inside the structure from day one. This is the quiet gap between those who keep what they build and those who lose it in a single bad year. It has almost nothing to do with how much money you make. It has everything to do with whether that money sits exposed or sits behind a wall. Beat 6. The honest caveat. To be clear, none of this makes you invincible, and no legitimate attorney will ever promise that it does. Courts can and do pierce poorly constructed LLCs when owners fail to respect corporate formalities, commingling personal and business funds, skipping paperwork, treating the entity as a formality rather than a real structure. Offshore trusts carry real cost, complexity, and reporting obligations under US law that make them impractical for most people. And no structure protects you from criminal liability, fraud, or claims tied to your own direct negligence outside the entity. Asset protection reduces exposure. It does not eliminate risk entirely, and anyone who tells you it does is selling something. Here is the meta-truth underneath all of this. Wealth that isn't protected isn't really wealth. It's exposure wearing a bigger number. The amateur spends every ounce of energy trying to grow the number on the balance sheet. The master spends equal energy making sure that number can survive the one bad year that eventually comes for almost everyone. A lawsuit, a business failure, a moment of someone else's bad judgment landing squarely on their doorstep. Buy assets. Protect assets. Repeat, it's not glamorous. Nobody posts their LLC operating agreement on social media, but it is the invisible architecture behind every fortune that survives contact with the real world, and the missing piece behind almost everyone that doesn't. The question isn't whether you'll ever face a claim against what you've built. Statistically, at some point, most people who own property, run a business, or carry professional liability will. The question is whether, when that day comes, there's anything left for them to actually take. If you want the next layer, how the ultra-wealthy use offshore structures, dynasty trusts, and multi-jurisdictional planning to protect fortunes across generations, hit subscribe. There's always another wall. We'll see you in the next case study.